Hello and welcome everyone. These are the lectures which I'm taking for the purpose of Delhi Judiciary mains. And first in series, I'll be doing Juvenile Justice Act, and we'll be starting with Chapter 4, which deals with procedure with respect to child who is found in conflict with law. So before I start, let's do some brief intro about the JJ Act. So the JJ Act deals with child child who has either committed some offense or some offense has been committed against such child. Okay, so this is what the JJ Act is covered. And for the purpose of JJ Act, child is person who is below 18 years. This is something you have to keep in mind. And another similar act we have is the POXO Act, which we'll do later. But POXO applies to sexual offenses against child. Okay. But for now, we'll be doing with JJ. JJ provides for the procedure as to how to deal with child, deal with such child. See, for now, JJ is a huge act. It also provides for adoption. It also deals with care and protection of child. A lot of things have been there, but for now, we'll be dealing with if a child commits some offense, then what is the procedure to be followed? Okay. So we begin with, so for now, just a brief introduction. You can open your barracks. If you keep your barracks with you, that will be easier for you to understand because I'll be doing this section wise as well as a procedural understanding here. So chapter 4 begins with section 10 up to section 26. Okay. Section 10 talks about apprehension. What is apprehension? You arrest the person. So let's begin. So if a child committed some offense, that police will arrest that child. Then police will hand over such child to the special juvenile police unit that has been formed under JJR. You go to section 2 and see which section of section 2 deals with juvenile police unit. That can be useful for prelims if you are in the Rajasthan or in MP, because since the JJ Act is not asked in the Delhi Judiciary prelims, we have to avoid all those small questions and just focus on the procedure and thereafter the case laws. So the child committed the offense, police arrested it, police will hand over such child to the special juvenile police unit. And what will this police do? They will either release the person on bail. If the person is not able to give the security, then that person will be sent. Generally, the person is sent to the jail. This is the general under CRPC. Okay, now we don't have the CRPC, but for the purpose of these lecture will be referring to the CRPC because even as of now, the new BNSSS has not been enacted even. So we'll be dealing with. So one thing to note here, the bail provision which has been given under section 12 is that child will be given bail whether in bailable or a non-bailable as a matter of right, because Section 12 specifically provides that notwithstanding anything contained in the CRPC, the bail will be given to the child in both bailable and the non-bailable cases. But there are certain exceptions to it. And those exceptions are if there is a reasonable ground, that reasonable ground the person will, that the child can come in association of some criminals, or the physical or the psychological danger to the child is there, or it would defeat the ends of the justice. In those cases, the court can deny bail. Okay, so if the bail is denied, where will the child will be sent? The child will not be sent to the police lockup or the jail. Such child will be sent to the observation homes or the place of safety. You can refer to section 2 definition again to see what are observations home, what are place of safety, and I'll be not doing it here. But you keep in mind that such child will be sent to the observation home or the place of safety. Thereafter, the child would be produced before the board. What is the board we are doing here? The Juvenile Justice Board. This is the main authority. You can look at section 4 to look at the composition of this to know more about JJB. But since we are not dealing with the prelims, we are focused on the mains. So we are just focusing what is the role of JJB here. So within 24, just as what we have in the CRPC also, such child will be produced before the board. And that what will be the role of JJB? The JJB will conduct inquiry. The time period to conduct the inquiry is a 14 month with an extension of 2 months. But if you need a further extension, then CMM or the CGM permission has to be taken. Even so, now section 14 also says that even after this extended period of 2 months, so we have 4 months plus 2 months equal to 6 months. Even after 6 months, if the inquiry is not completed in the petty offences, then such proceeding will be stand terminated. Now, just for the reference, what are petty offences, serious offence, and heinous offences? Keep in mind that this is only the JJ Act which has made differentiations, which has categorized offence on the basis of petty, serious, and heinous. What are these categories? Now, see, this is 3 years, this is 7 years. Any offence which is punishable less than 3 years is a petty offence. Any offence which is committed for which the punishment is more than 3 years but less than 7 years is a serious offence. And any offence for which the for any offence for which 3 year, 7 year. Any offence for which the minimum is the 7 year and there is no maximum, but the minimum is 7 year. These are the heinous offence. We had a case also, Shilpa Mittal case of Delhi High Court that considered what will be happen in the cases where the offense, maximum punishment is more than 7 years, but no minimum is provided. Again, Section 302 IPC. What is the punishment for murder? Punishment for the murder is life imprisonment or death. Also, we had 10 years for culpable homicide. Here, the maximum is given, but there is no minimum. So, in this case, the court said that such offense would come under the category of serious offense. Now we are clear about what are petty, serious, and heinous. Now let's move forward. The board will conduct inquiry. We have seen the time period, that is 6, and if further there is an extension of 6 in the petty offense, there will be termination of proceeding, and for the further extension, it will take the time period of CMM, CGM. Now, inquiry will be about whether the child has committed the offense or not. Child committed an offense or child didn't commit the offense. This is what the inquiry ka result would be. Okay. So now, if the child committed the offense, the order would be passed under section 18. If the child did not commit the offense, the order would be passed under section 17. And if the child, so the obvious baat hai ki if child didn't commit the offense, the person will be released. But if the child is in need and care or protection, then appropriate direction would be issued by the board in such cases. So we have seen the post inquiry child is found to have committed the offense. Commit होगा तो ट्रायल शुरू होगा. तो where will तो दो क्वेश्चन आते हैं ट्रायल में. There are two questions that we need to decide. Who will conduct the trial and the procedure of such trial. Okay. Who will conduct? It is the Juvenile Justice Board. Exception है एक, वो हम देखेंगे. What will be the procedure? Procedure ये रहा. Petty offense, summary procedure. Serious offense, summon case procedure. Heinous case, if the child is less than 16 years, then summary procedure. If the child is above 16 years, then यहाँ एक separate procedure start होता है. So, if child is above 16 years and he commits some heinous offense. In such case, there will be an assessment. What will be that assessment? Now, that assessment under section 15. Look at section 15. Section 15, preliminary assessment into the heinous offense. There will be so where section 15 apply if the child is above 16 years, commits any heinous offense, then this assessment has to be within 3 months after the first production. ये section 14 में given है. Now, what will be the assessment about? Assess what? The court, the Juvenile Justice Board, will assess the mental and the physical capacity to commit the offense, and ability to understand the consequence. So the Juvenile Justice Board will see whether the child who has committed the offense had the capacity to commit that offense, whether he was understanding the consequences of those offenses, and then and what were the circumstances in which that heinous offense was committed. For example, a child committed murder, a child committed some rape, for example, for which the minimum sentence is more than 7 years, so that makes it a heinous offense. Now, if in heinous offense, they will be looking while assessing the capacity, the Juvenile Justice Board will take the help of psychologist. That is not meant to conduct a trial, but just to assess whether child is the capacity. Why we are doing this? Why we are doing this preliminary assessment? We are doing it to to find out whether such child should be tried as an adult or should be treated as a child only. Because if you all remember, after the Delhi gang rape case, there were a lot of hue and cry that the child who has committed such heinous offense, he is no more a child. How can you treat that person as a child? So there comes a question for for the child who are between 16 to 18 years committing such heinous offense, if they had such capacity, if they know the consequence, that means they are no longer child. They don't deserve to get the benefit of this JJ Act. We will discuss what are the benefit of trying as a child and what are the benefit of trying as an adult. We will look into it in the further, but for now, post assessment, the JJB will decide if disposal of the case would be by the board or by the children's court. So, if the JJB decide that child should be treated as an adult, then the case would be sent to the children's court. If JJB decide that the disposal would be by the board, then the summon case procedure would be followed and the disposal would be by the board only. And then disposal by the child under section 18(3) में order आएगा. So we have seen that when the post inquiry, if it is found the child has committed an offense, order under section 18. If child didn't commit an offense, under section 17 आएगा. So we have seen after section 15 assessment कर लिया, assessment के बाद we found out कि board will dispose the case. You follow the summon trial, you pass the appropriate order. The order which any JJ Act would be passing under section 18. डिस्पोजल अगर चिल्ड्रंस कोर्ट की जैसे करना है देन 18(3) में ऑर्डर आएगा कि मैटर को चिल्ड्रंस कोर्ट में सेंड कर दो. ओके, नाउ post trial, when these offences include petty offence, serious offence, heinous offence by the child less than 16 years. In cases में what are the punishment, what are the order that the JJB can pass if the child is found in conflict with law. So they can admonish the child and send him to go home after counseling. They can conduct a group counseling or some activities of such child. They can order some community service, for example झाड़ू लगाओ या ये करना है, कुछ सफाई करनी है, वो सब कम्युनिटी सर्विस में. या फिर बोल सकते हैं कि पानी है तो गांव में अगर तो हेड पंप के यहाँ पे या पानी पिलाने का काम, वो सब कम्युनिटी सर्विस में आएगा. देन दे कैन ऑर्डर टू पे फाइन, दे कैन बी रिलीज्ड ऑन प्रोबेशन of good conduct and placed under the care of parents, guardians, or any fit person or under a facility. Facility in the JJ Act are shelter homes, we have observation homes. So under such facility can be sent, but only for the 3 years time period. This is something you need to keep in mind. Okay. They can either be sent for the special home. You look at the definition under section 2 to find out what are these special homes, what are different places are there. Just to tell you, there are different institutions under this are observatory, observation house, shelter house, special home, um, we have place of safety. These are there, okay? Now, or be sent. Place of safety is like a jail, but it's not a jail, but that's where if a child is found to be guilty, is sent. Okay, and when such person is sent to special home, then the court can also make an order for reformative services like education, skilling, therapy, psychiatric, all of these. And when a court makes an order under clause A to G, then in such cases, the court can also pass an additional order to attend school, vocational training, therapy, de-addicting program, or not to visit any specified place. For example, if the child who is guilty of eve teasing in a girls' hostel, then the court can order that the child will not travel to this road where the girls' hostel is situated. Okay, such order can be made. So you see what is the benefit of trying as a child. The first thing you observe is that the punishment are not so severe. Plus, there are scope of reformation because you are providing a lot of reformative services like education, skilling, therapy, psychiatric treatment. Second, and second benefit is you will see later on that on the basis if such child is convicted, then whatever disqualification are there on the conviction does not apply to a child. What are the disqualification? If you are a convict, if you are a convict, you cannot apply to a government job, right? Or if you apply, you have to disclose that you have been convicted. So there are certain disqualification. Those disqualification does not apply to a child. Okay, this is another benefit. Now, but other than now, we have another category where the child is above 16 years who has committed heinous offense trying as adult, and such matter are sent to the children's court. So if the child is trying as an adult, so you see there is a parallel, parallel jurisprudence here. There's a parallel proceedings, or we can say parallel proceedings here. Okay, section 19. So under section 19, the power of children's court come in place. Now, when the JJB refers a child to the children's court, the children's court will assess whether there is a need to try such child as an adult. So there is a reassessment. So there is one thing is section 15 is not binding on the children's court. Okay. Now, after such assessment, the Children's Court finds that the trial of child as an adult is necessary. Then they will follow the process of CRPC under Section 21. The sentence is subject to Section 21. Section 21 of JJ Act. It says that no death or the life imprisonment can be awarded to a child. And in a child-friendly atmosphere, so what is the CRPC? If you remember Section 27, you will notice the reference of children's code, that such can be done by CGM only, right? So that is what the reference of CRPC is here and the procedure here. Section 21, death or life imprisonment. Now must be thinking what will be the trial process because earlier we have seen summon case. Here, if you are applying the CRPC, then you will see if it is a summon case or a warrant case. Anyway, it would be going to be a warrant case, right? Because the punishment is more than 2 years. That is what the warrant case is about, right? And even there's a section, there's a particular section in CRPC in which you convert the warrant. You can you can convert the case, but oh no, that is for converting a summon into a warrant trial, right? Which section it is? Remember and tell me in comment section, okay? After while passing a sentence, there has to be a mandatory plan. A child plan has to be the children's court, while making a sentence under Section 19, they have to make sure that they also award some mechanism of a care plan where rehabilitation is there. Rehabilitation again is skilling, education, and all of these are there. Okay. Now, if sorry, so if the children court is of the opinion that the child should need not be, no need to try it, then again section 18 will be followed. Okay. Now, post trial, the child will be sent to the place of safety till 21 years of age, and then thereafter he will be transferred to the jail. We will see what is the procedure here. We will discuss it in detail that how this procedure happens, and then the reformative services would be awarded. Then, while the child would be in the place of safety, there'll be yearly follow-up report. So periodically, District Child Protection Unit will go to that place of safety and they periodically report on the progress of the child, and then they submit a yearly report to the Children's Court. What is the reference? What is the relevance of this? We will see just in a while. Okay. Now, this is the entire procedure that we have seen. Okay. What is the procedure? Who will conduct? Now, something that I have been referring earlier about the 21 years age. Now, for example, if an offense is committed when the child was of age 17, he was brought before the JJB. Now, अगर वो JJB के सामने लाए, suppose जब 17 साल 10 महीने का था, मतलब less than 18 years, and less than 18 years is a child under JJF. लेकिन while the inquiry was ongoing, he covers the 18 years. Now he has become an adult during inquiry. So if that happens, Section 5 says you treat that as if he continues to be a child. And for example, if that 17 years kid is brought before the HAB when he was age 19, that is above 18 years, he is no longer a child. So this is a situation when the offense was committed when he was a child, but he was apprehended when he was not a child. So what will happen in that situation? Will that child be treated as an adult? No, treat as a child that has been given under Section 6. So in either cases, the law is when a child commits an offense, he will remain a child. He will not become an adult just because he was arrested later on. Okay. Now he was sentenced. The procedure happened. The inquiry conducted. The trial happened. The sentence. So while the sentence was passed, he was of age 20 and he was sentenced to place of safety by the children's court because he committed heinous offense for 3 years, for example. Now he attains 21 years of age, एक साल बाद, so 2 years of sentence remain. In that situation, what will happen? So जो report थी, I was saying ना, what was the relevance of that report? So जो report यहाँ yearly submit हो रही थी, the children's court will evaluate if child has reformed during that time period or not, and if child can be a contributing member to the society. So report under section 19(4) का relevance यहाँ आता है. Thereafter, the decision will be passed. The decision can either be to release the child if the child is found to be a contributing member of the society, or the child will be sent to the jail like a normal adult person, and he will complete his remaining sentence. Okay. Once he was released, then there'll be a monitoring authority appointed to monitor the child, and where this monitoring authority will be, the state government has to prepare that list. Okay. Now we have seen some miscellaneous provisions that are important right now is Section 21, which says that the death or the life imprisonment or any possibility of release, where the possibility of release is not there, such sentence cannot be passed to a child. This is a clear indication that the rehabilitation and the reform is the main objective of the JJR. Okay, now section 22. It says that chapter 8 of the CRPC does not apply. What is chapter 8 of CRPC? It is the security for keeping peace and good behavior. So while you sentence a person, you said that okay, post conviction or while on conviction, you have to give certain security that you will not breach the peace from now on. So this section does not apply to child. Now, section 23 says There's a joint proceeding under Section 223 CRPC. What is Section 223 CRPC? It says about the joinder of accused. Some accused can be joined. What are the provisions? What are the condition under which joint accused can be joined? If you know if there's a series, if the person together committed an offense. So just recall Section 223. Now, the Section 23 says that there cannot be any joint proceeding where the accused is not a child. For example, there are two people, okay? This person and this person. This person was a child, but this person was an adult. So this section says these two people cannot be tried together because this person is not a child. So a co-accused who is not a child cannot be tried along with the who is not a child cannot be tried with the child under this act. Okay, so this is section 223. Section 24 says the disqualification, which I had also mentioned earlier. The benefit of trying as a child is that the disqualification which are attached with the conviction are not there, except section 19 clause 1 subclause 1, that is when the child is tried as an adult. So there's an exception to it. Second thing, it says there will be a destruction of record after the expiry of appeal. So if the appeal has been expired and then after that all the record of such child will be destroyed. Again, there is an exception which is a child who has been tried in as an adult. So this section 24 tells you what is the benefit of trying someone as a child or trying someone as an adult. Okay. Now, Section 25 says no retrospective effect of JJ Act on the pending cases. Simple. Section 26 says about the runaway child. What are the runaway child? For example, an order has been passed by either JJB or by the children court that the child will be given to the shelter home या कोई facility या place of safety कहीं भी observation home कहीं भी भेजा गया है and child runs away from such place. And the police officer, here any police officer can take the charge of such child. Then this police officer will produce the child before the JGB and pass an order. So which JGB will be taken to? The JGB which passed the order originally, or whichever the nearest Juvenile Justice Board is the JGB, where the child will be taken. Now, that Juvenile Justice Board will look into the reason of running. Why that person running? Was there any assault? Was there any exploitation? So, after looking at the reason, the child can be sent either to the same place or other similar place, and then pass some additional special direction if necessary. But in case of running of child, there will be no additional proceeding against the child. You would not punish the child for running. So this is in brief is chapter 4, where the entire procedure of child who is in conflict with law has been discussed. Now, again, a very quick recap. Okay, so the quick recap is JJR, the police will hand over to the special police. They will take to the JJB. The JJ will inquire if the child has actually committed offense or not. After the inquiry, we will check if the child has committed the offense or not committed the offense. And if committed the offense, order will be passed under section 18. If not committed the offense under section 17, the person will be released. Now, for the offenses uh, more than 16 years in the heinous crime, there will be an assessment under section 15. The assessment is about the capacity and the consequence understanding. If the child is found to have the capacity, he'll be sent to the children's court and will be tried as an adult. Post trial an adult under section 19, he will be sent to the place of safety and the CRPC will be followed here. Section 21 restriction will apply, that is no life imprisonment or death will be awarded here, and then reformative sentence to be followed. Okay, and now